Right off the bat, this case is already giving chaos. We've got missed reports, confusion about court instructions, and a defendant trying to navigate a system that clearly didn't go smoothly. But here's the twist: the judge isn't buying any of it. This isn't just about paperwork anymore, it's about credibility. And in a courtroom, once that starts slipping, things can spiral fast. The real question is, was this truly a misunderstanding, or is something deeper going on here?
Court calls the case People versus Shauna Stump.
Thanks, Your Honor.
This is where things get interesting. The defendant is laying out a situation that, on the surface, sounds like a bureaucratic breakdown. No paperwork, unclear instructions, delayed communication. But here's the legal reality: when you're released on bond, the responsibility ultimately falls on you to comply with conditions, regardless of confusion. Courts expect proactive behavior, not reactive excuses. So the judge is now weighing two things: was this a genuine system failure, or a failure of personal responsibility? What do you think? Should confusion be a valid excuse here?
During the course of the trial, it was about a woman who he was involved in a supposed committed relationship for almost 3 years.
Assistant Public Defender Constable Basie on behalf of Shauna Stum, who was present to my right. You can state your full name for the record.
Shauna Stum.
Your Honor, today is the date and time set for PCC. At this time, my client is wanting to waive the right to a preliminary exam and seek an offer of 7411 at the circuit court level.
Well, except we have a problem. You have the violation report,
I do not.
Mr. Allen. He was ordered over to community corrections and has failed to report.
Okay, so this is what happened. So I was PR bonded on last Tuesday meeting or afternoon, I guess. Well, nothing ever got sent over to the courts or to the jail. So I didn't have any paperwork to leave with or anything. So I had to call up here after I got let out, finally, after whoever was at the jail working at the time had figured out what was going on with the case and my bond and everything. I had to call up here on Thursday to find out what I needed to do. And all they told me was I had court today. That was it. And they told me at 9 and not 1. So
Your Honor, if the court is willing, I could have my client report to community corrections immediately.
Yeah.
I could walk her down there myself.
I do apologize. It was not intentional in any way, shape, or form.
Now we're entering risky territory. The moment the conversation shifts to substance use, credibility takes another hit. Notice the hesitation, the back and forth answers. That's a red flag in any courtroom. The judge isn't just listening to what is being said, but how it's being said. Inconsistent statements can completely undermine a defense. Legally, this matters because compliance with programs and honesty about substance use often influence sentencing decisions. So now the stakes just got higher. This isn't just about missing a report anymore, it's about trust.
He was to report to community corrections beginning June 20th for intermediate supervision. They tried to contact you by phone on the 21st when you didn't show up. Unable to make contact, your voicemail was full.
Yeah, I own a business, so probably was full. I'm very bad about deleting my voicemail.
I also had a conversation with her about that, Your Honor. I ran into a similar issue with her, so
if you do get tested, you're going to come back negative for everything?
Yeah. No, I'll come. I should.
Yeah.
For Suboxone.
What?
For Suboxone. Yeah, I should. Well, no.
What?
Yes, sir.
Her baseline level would still show that she's
that I have
positive.
Yeah, for few.
but we're confident that it would be going down.
Going down, correct?
Are you in a program?
I am not currently in a program, no, sir.
So where are you getting this box?
Well, I was. I'm not any longer, but I was.
Okay, so let's play the game. So when did you come out of the program?
I'm sorry.
When did you come out of the program?
6 months ago. I still have a valid script from a year ago. Oh my God. I can't handle this right now. I'm gonna have an.
Really? Me either.
I know, I'm so sorry.
So here's what's gonna happen.
This is the turning point. The judge directly calls out dishonesty, and that's one of the worst positions a defendant can be in. In court, judges are far more lenient with mistakes than they are with lies. Why? Because the entire justice system runs on credibility. The moment the judge believes you're being evasive, every explanation after that gets questioned. You can actually feel the shift here. The tone changes, patience wears thin, and now the focus isn't just the violation, it's the integrity of the defendant.
Call her back out maybe, but I'm gonna let you talk to your attorney.
Okay,
So that what happens is that your attorney, I'm sure, will explain to you that the one thing, how you have to deal with me is you need to tell me the truth.
mhm.
And you're lying to me and skirting around a lot of the questions that I'm asking. You are. And you know you are.
I am, yeah, because I'm terrified.
Yeah, me too. So, Mr. Allen, you can take her, put her back into custody at this point.
Oh
We'll
my
call her case back up at some point. Mr. Obese, you can take some time to talk with her and
Thank you, Your Honor. We would just ask that the sentencing be pushed out so my client can get back into compliance. As I said, I'm going to be walking her over to community corrections as soon as we're done here. And she is interested in resolving this case, Your Honor. She wants to enter a plea of 74-11. I have the waiver here for the waiver of her exam.
so she wants to waive up and plead.
Here's where the defense tries to recover the situation. They're shifting the narrative, acknowledging fault, showing willingness to comply, and pushing for a resolution through a plea. Strategically, this is smart. Admitting responsibility can sometimes soften the court's stance. But the judge is still skeptical, and understandably so. The key issue now is, can future compliance outweigh past dishonesty? Because courts don't just look at what you say, they look at patterns. Would you trust a second chance here?
That's correct, Your Honor.
Well, how do I know that she's going to get in compliance with this? Because she wasn't telling me the truth when she came in.
Your Honor, my client was, to say it in the simplest way, she was terrified, Your Honor. She understands that, you know, there's no excuse for her behavior. Like I said, she's admitting to the violation at this time.
And I do apologize.
No.
Well, what is she admitting to? Because she, first of all, blamed the jail. Then she blamed other people for not getting me. So what is she, what's the true, what?
Your Honor, she's willing to take responsibility that it was on her to figure out what she needed to do. And she shouldn't have waited for somebody to send her paperwork. She should have gone over to the courthouse, gotten the paperwork herself, gotten everything she needed, went to community corrections. She does want to rectify the situation, Your Honor. We do want to fix this. You know, if the court deems additional testing, my client is open to that as well. So we leave it to the discretion of the court, Your Honor.
What do you do during the day?
I clean houses, Your Honor. I actually own a cleaning company, so. Yes, sir. I know. I have grown but one.
Order, but a new order. But we're gonna not do it quite that way. With the urine ET, it's intermediate drug testing urine and ETG 2 times per week.
And there it is, the consequence. 5 days in jail might not seem extreme, but symbolically, it's powerful. The judge is sending a clear message: honesty matters more than perfection. Notice how the judge even points out that the outcome could have been different if the truth had come out earlier. That's a critical lesson in courtroom dynamics. Owning your mistakes early can significantly change the outcome. Instead, this situation escalated because of how it was handled, not just what happened.
Going to waive your right to a preliminary examination.
Yes, sir.
And you understand that a preliminary examination is a proceeding where the people have to show by probable cause that the offense alleged was committed and that you committed it. You understand that you'll not have that hearing and you'll proceed to circuit court for further resolution.
Yes, Your Honor.
People also waive their right.
Yes, Your Honor.
Preliminary examination having been waived, defendant is bound over to circuit court on a single charge.
Yes, Your Honor. Thank you. We waive formal readings and stand mute to the charges at this time.
Defendant having waived formal reading, standing mute. Court will enter not guilty plea. Pretrial will be set for. And well, give me the out date.
It's August 12th at 1:30 before Slay Monday.
August 12th. But what is the other date?
The other day would be July 8th at 1:30.
August 12th.
Yes.
Pretrial will be August 12th, 2024, 1:30. Judge Slay Monday. You admitted to the violation of bond, and her bond will be continued as previously said. I'm going to enter a new order that she'll have to comply with. Anything you want to say before I sentence you on the violation?
No, I apologize, Your Honor, for not being honest.
I don't even know why you did that.
I don't either. I'm old enough to know better, honestly. So.
I really don't. I don't understand why you came in here. You're lying to me, you're lying to your attorney, you're lying to everybody.
I'm lying to myself. So I understand, Your Honor, and
Well, I always tell people, I'll deal with the truth and we can deal with each other when it's that way. But if you lie to me,
yeah,
that's
difficult.
That's going to be the bigger problem.
I understand.
So the sentence on the violation, defendants to serve 5 days, Washtenaw County Jail. Defendants remanded. Time served. What, for back there for an hour or two? Seriously? And Bill BC, if you had said yes, I would have come off the bench and just great.
I did say.
Yeah, okay, man.
I told her we'll talk after. That's it for me.
Oh, it is.
So we won't being in your courtroom.
Yes, you ended on a fine note. Take care, sir. Court does.
This second case flips the script completely. Now we're dealing with character arguments, defense painting the defendant as admirable, while the judge is laser-focused on contradictions in behavior. This clash is fascinating because it highlights a core legal tension. Do past good deeds outweigh present misconduct? Then suddenly, everything pauses due to a medical situation. And moments like this remind us, courtrooms are unpredictable. Real life doesn't pause for legal arguments. But when proceedings resume...
Call the case of the people versus Robert Jones.
Assistant Prosecuting Attorney Morgan Barroso on behalf of the people.
Good afternoon, Your Honor. William Amadeo, P76194 for Robert. Robert, please state your name for Judge Simpson, his staff, and Prosecutor Barroso know it is you.
Robert Louis Jones, Jr.
First of all, Your Honor, thank you for hearing this motion. I'm taking over this case. I know you and your staff read everything, and I wrote in detail about this man. I wouldn't represent somebody who would disrespect your court, Judge. And clearly he dropped the ball here. Dropped the ball in a bad way. But the life he's led is admirable.
Whoa. Really?
His history.
Okay. Mr. Admirable, because I trust you and I believe you, I want to be sure you know what happened during the trial in terms of the evidence that came in.
I understand, Judge.
Which part do you understand?
I understand that this case never should have went to trial.
No, he's entitled to a trial. You also know me. I'm just going to be real. You're telling me, and I know you're telling me in good faith, that this is somebody admirable, and I'm not going to punish you for this. But a woman writes me a letter that there is this committed partnership that he's in for the last 7 years. Right?
Yes.
During the course of the trial, it was about a woman who he was involved in a supposed committed relationship for almost 3 years. If that's not bad enough, what led to the entire dispute was because he took some other woman to the movies, and got seen by somebody. So I'm not saying it's falling on deaf ears. I'm not, but I don't know that somebody can start out saying this is an admirable guy. I mean, maybe that's people's standards. It's not mine.
Well, if I could try to clean up the mess.
I don't know that your broom's that big, but go ahead, take a shot.
His partner, who's an amazing person, is in the court today, and she's going to be stronger than any probation officer would be. She's heartbroken over this. I understand what came out at trial, and I understand how you were disrespected. But I also understand, if I could at least argue this point, and Judge, I understand you're the boss here, but I have to advocate.
Go ahead.
I get that, Judge. He is a great father. He's a hard worker. He had no previous criminal history for 20 years. I'm not asking for a gift. I'm asking that he goes on tether and house arrest just to be able to support his daughter. If I was on this case, Judge, things would have went a different direction. I'm not trying to throw anybody under the bus, but I do have control of this man. He is humbled. He has been given a major wake-up call. I ask you to consider all those factors when you render your decision today.
All right. Can I just say one other thing? It wasn't even so much about, it wasn't about disrespecting me. I think you need to also understand that part, because I don't know what he told you. But it was what he was doing during the course of the trial to the victim while she was testifying to victim one, the one that he was involved in, and then her sister. And I watched him the entire trial. And if his eyes could have ripped. Is he okay? Because if he's not okay, they could take it back.
I'm fine.
Are you okay?
Yes, I'm okay.
Okay. Can he sit down, Judge?
Yeah, he can sit. No, I'm not. You're gonna have to take him back, because I don't know what's going on with him. Because I'm not. He's not. He just fell a second time. This is Thursday, Friday. What do we have now? What I would do, I'm not going to proceed with this motion without him, but I don't think he's in. I don't know what's going on. So I can hear it tomorrow. I can hear it Monday. I can hear it whenever.
Is there any way tomorrow afternoon would work at all?
Like I said, I'm here, but I'm not trying to force anybody to be here. I don't think any of us expected this to happen. So, I mean.
Forgot, I haven't had a prep day in about 3 weeks.
I don't know. You've been doing just fine without it.
Like to not work all weekend.
Oh, wow. I'm sorry.
If we had to go to Monday, could we do Monday afternoon? Because I got,
I am here literally all day that day, so whenever works for you.
what time would work for you, Judge, on Monday afternoon?
2:00. All right.
And if I were to revise anything in the emergency motion, would that be acceptable to the people in the court?
Well, if you send it to me and then, I mean, it depends on what the revision is, but I mean, I'll hear anything anybody wants to say. So I'll just adjourn this out to Monday is what, the 1st?
Yes.
All right, July 1st, 2024 at 2 p.m.
Both of these cases highlight one powerful truth. Courtrooms aren't just about facts, they're about credibility, accountability, and perception. In the first case, a lack of honesty turned a manageable situation into a harsher outcome. In the second, character arguments clashed with real actions, leaving the judge to question what truly defines a person. These moments show how every word, every action, and every decision can shape the final ruling. If you found this case as shocking as we did, make sure to hit that like button, share your thoughts in the comments, especially who you think handled their situation worse, and don't forget to subscribe for more jaw-dropping courtroom breakdowns.